SJC-11947, Commonwealth v. Ronnie Elliot.
Mr. Elliot, good morning. We're all here,
Good morning.
and you've got 10 minutes, so we'll hear from you. Please keep your voice up to make sure that all of us can hear, okay?
Yes. Thank you. I can't hear.
And you may start.
Hello, can you hear me?
We can hear you.
In 1995, the petitioner was a 17-year-old juvenile, twice committed to the Department of Youth Services, charged with first-degree murder in Suffolk Superior Court. An offense. Hello? I can't hear.
No, we hear all that you're saying. Just keep your voice up.
I'm having. Hold on.
Hello,
Yeah, we're still here.
can you hear us?
We can.
I'll put him back on. He says he's having trouble hearing. That's going in and out. Are you having trouble on your end?
No. No, we
Okay.
can hear.
I'll put him back on.
Hello?
Hello.
All right. All right. In 1995, the petitioner was a 17-year-old juvenile, twice committed to the Department of Youth Services, charged with first-degree murder in Suffolk Superior Court, an offense that would trigger the mandate of Mass General Laws, Chapter 119, Section 61. The court should have ordered a transfer hearing because the petitioner was a child 14 years old or older, twice committed to the Department of Youth Services, therefore meeting the threshold eligibility criteria for a transfer hearing. After the transfer hearing, pursuant to Mass General Laws, Chapter 119, Section 61, since repealed, the Suffolk Superior Court lacks subject matter jurisdiction over the criminal docket matter. In 1990, the language of Mass General Laws, Chapter 119, Section 61, the 1988 edition was amended by an act, State 1990, Chapter 267, Section 3, amended specifically the language pertaining to age, and some of this language consisted of a complaint made under Section 52 to 63 inclusive that a child who had previously been committed to the Department of Youth Services as a delinquent child, which was defined by Section 62, as well as an alleged offense, was committed while the child was between his 14th and 17th birthday. And in its place, the language stated that, in part, a child who was 14 years old and older was entitled to a transfer. For the offenses of murder on July 10th of 1995, the petitioner was charged in the Roxbury District Court with first-degree murder, assault with intent to murder, possession of a firearm, and possession of a firearm without an FID card. At the time, the petitioner was lawfully committed to the custody of the Department of Youth Services pursuant to General Laws, Chapter 119, Section 58. The petitioner was committed to the Department of Youth Services on June 2nd, 1993, and again on April 20th, 1994. Both commitments were until the petitioner turned 18, and the petitioner did not turn 18 until June 20th of 1996. And at no time did the petitioner have the benefit of a juvenile transfer hearing pursuant to Mass General Laws, Chapter 119, Section 61, as prescribed by the law for any offender committed to the Department of Youth Services prior to being charged and tried in the Superior Court. I ask this court to closely analyze the language of the 1988 edition as well as the 1994 edition of Mass General Laws, Chapter 119, Section 61, which has since been repealed. And the legislative intent remains apparent by replacing the age-specific language of the 1988 edition with the language of the 1994 edition, stating in part a child who is 14 years old and older. And being that this petitioner is having no other remedy known available to correct the error raised herein of the subject matter jurisdiction violation in the nature described, the petitioner requests that this court order the petitioner's conviction and sentence set aside and remand this matter back to the Superior Court with orders to dismiss. Thank you.
Mr. Elliott,
Yes.
what was the date of the alleged killing?
I can't hear you.
What was the date of the alleged killing in this case?
The date of the offense was on June 10th of 1995.
And on June 10th, 1995, how old were you?
I was 17.
And at that time, weren't you deemed an adult at that time?
No, I was a juvenile committed to the Department of Youth Services.
So your contention is that even though you were 17, you were still a juvenile?
Yes.
All right. Any questions? All right, Mr. Elliott, thank you so much. Why don't you wait and you can hear Mr. Lynn, all right?
All right.
Mr. Lynn?
Thank you.
He says he was a juvenile at the age of 17 on June 10th, 1995. My understanding is that he would be deemed an adult at that time, that the statute changed subsequently.
That's the Commonwealth's position as stated in its brief, Your Honor. May it please the Court, Paul Lynn for the Commonwealth, also for the benefit of Mr. Elliott. Yes, both Chapter 119, Section 60, which defined the juvenile court jurisdiction at the time, and Chapter 119, Section 52, which defined delinquent child at the time, both said that a person ceased to be a delinquent child and became an adult in the eyes of the criminal justice system at that time when that person turned 17. So when Mr. Elliott turned 17, he became an adult in the eyes of the criminal justice system and therefore was not entitled to a transfer hearing under Section 61.
He tells us he was in juvenile custody at the time.
He was, and there is language in some of the case law talking about a person who is in juvenile custody having to have his complaints dismissed, but that's if they began in juvenile court. That's in a situation where the juvenile court had jurisdiction originally, there was a transfer hearing, then the case had to be dismissed and indicted in the superior court. It doesn't apply simply to any crime, no matter how unrelated it was to the murder on which the defendant might have been in DYS custody. If that were the case, even an 18-year-old at the time would have been subject to a transfer hearing. I would also just very briefly address the defendant's argument under Miller and Diachenko. He was convicted of second-degree murder. He is eligible for parole. Based on the parole records I've viewed, he's had 2 parole hearings. That's all that Miller and Diachenko require. And unless there are any further questions, the Commonwealth would otherwise rest on its brief.
All right, thank you.
Thank you, Your Honors.